This is power and purpose personified, walking towards justice, fighting for freedom. This is speaking now, empowering the next generation to know how to live with confidence and precision, to move with mastery and meaning. This is a spirit that is free, traveling one coast to the next, escaping the comforts of home. This is finding new friends and exploring the warrior within to destinations amazing, to destinations unknown. This is what it means to keep pounding, to cheer for the home team without hesitation. This is love and life, success and sacrifice. This is Yolanda Troutman, and this is The Conversation.
Good evening, good evening, good evening, everyone. I hope you all are having a fantastic Wednesday as you are wrapping up your hump day. I am your host, Yolanda Troutman, and welcome to The Conversation. This show is, this show really is all about timing. Because when I had the idea of coming up with this particular show, Deconstructing the trial involving the murder of George Floyd, it was not I certainly could not have imagined we would have had a verdict by today, and to be able to have so much to talk about. So this show this show is all about answering questions. This show is all about talking about and deconstructing the trial itself. This show is definitely about addressing the issues of now. What do we do now that the trial is over? Now that we have a verdict? Now that we are awaiting sentencing? What does this mean for matters that upcoming matters of trials that involve police brutality, especially in wake of Daunte Wright and some of these other cases that have happened most recently? What does all of this mean? So this is a conversation that has you, the audience, in mind. So if you have questions, make sure you drop them in the comments. If you're watching us on YouTube, then leave us a comment. We'll see them. We are going to answer as many questions as we possibly can tonight. I'm so excited with my co-host and guest. If you've been following the conversation, especially since season 2, you already know him because we've done a couple of these together where we've talked about high profile trials or just about the justice system in general. And a lot of this started back in season 2, if you started catching the conversation back then. If not, definitely go back to the website because those other episodes are there. But this really started in wake of the Ahmaud Arbery case. And so I had this idea of coming up with a series that really broke down the criminal justice system, and I chose to call it The Indictment. It was supposed to be originally just 3 or 4 parts where we were going to talk about various parts of the criminal justice system, and then it just somehow evolved into this multi-part series. So regardless of where you're tuning in from, drop us a comment, let us know where you're watching from, especially for those of you from other states. It's always fun to see where people are joining us to tune into the conversation. And again, of course, if you have comments, make sure that you drop them in there. And if you're catching the replay, then we definitely respond back to comments as well. So of course, before we get started, make sure if you haven't done so already, first of all, subscribe, like, and follow us at all things social media at The Convo Pod Show. Literally, if you put that in Google, everything pops up, all of the social media, and the YouTube channel. If you're catching us on YouTube, or if you haven't been to the YouTube channel, very easy to find. Go to YouTube, type in The Conversation with Yolanda Troutman, and it pops up. So make sure that you go and subscribe. And if you're watching our live feed from there, then of course, drop in your questions there. Also, if you haven't already done so, make sure that you check out the website that has all of the past episodes from seasons 1, 2, and of course, now we're into season 3. So where you can catch all of the past show episodes, the indictment series I mentioned, all of the episodes we've had so far on season 3. And then, of course, if you haven't already done so, pick up your merch. We definitely have merch on the way as well. So we have a lot to talk about. So I don't know if you caught the live either on the Facebook page, the personal page, or on the conversation page. But we talked, and I talked a little bit about post-verdict and what some of that means. But this trial is particularly significant because it really addresses a number of issues as it relates to the criminal justice system in a way I don't think we've ever seen before. And I say that because we're trying cases in the age of COVID. This case was also monumental because the entire crime was captured due to the courage of a 17-year-old. This case is different because of the implications. And so when we get towards the end of the show, we're going to talk about now what can we do now? Because there's no doubt about it. that the murder of George Floyd sparked a movement. It sparked a movement not just locally. It didn't spark a movement just nationally, but it sparked a movement internationally. So ask your questions. This is the time to answer your questions, but let's get into it. So my guest, you all know him if you've caught previous episodes of the conversation. He is one of my favorite attorneys. I've known him for years, and what he brings to the show is a very interesting perspective. I bring the perspective of being a former judge and, of course, a defense attorney. He brings a very interesting perspective because he's a former prosecutor that tried homicide cases and then decided to go into private practice as a defense attorney. So you all know him. Everyone, welcome to the show. None other than Rob Corbett. How you doing, counselor?
I'm doing great. Thank you for having me on tonight.
Well, it is always a pleasure, and you always answer the call when I say, you know what, we got to talk about it, right? And you like, yeah. Let's do it. Let's get it done.
That was like I said, that was good timing in terms of, I think when you scheduled it. I think it's probably known of when closing arguments were going to take place, but obviously nobody knew how long it was going to take for jury deliberations.
And not this quick. That was well, I don't know. Let's start there. Do you think the deliberations were quick, given the facts? I don't know. What do you think?
Yeah, and I've talked about that with a couple of people in terms of they say that, or they thought it was a quick verdict. I've had verdicts come back longer, verdicts come back quicker. I've had trials that were a fraction of the length this was, and they still took as long or longer to come back. My thing is, as long as they don't come back like right away within that first hour, then I feel like, okay, I'm in it. At least, somebody's listening. But when they come back right away, you're like, hey, what was I up there for? Y'all didn't listen to anything I said. Y'all already had your minds made up. So for them to take like a day and a half, and it's not as much or as many witnesses that were called, like most cases, is not complicated, or it wasn't complicated. It all comes down to, they talked about the time, sometimes I say it comes down to moments, but this came down to 9 minutes and 29 seconds. And that's what it was all about. And they showed the video so many times during the trial that by the end, I think they knew or had an idea of where they were headed, but they need to kind of give it a good show and say, look, we're going to talk about this for a little bit, not just go rushing right back in. But, so they said, hey, by the time that second day rolled around, they're ready to go.
For sure. So for those of you who are just tuning in and joining us, definitely need you to let us know what you're thinking. I would imagine that the vast majority of people who are tuning in believe that the verdict is what it needed to be. But what are your thoughts on the trial itself? Like, what questions did you have? How did you think the prosecution did? How do you think the defense did? Did you think the judge was fair? We're curious to see what your perceptions are in terms of what you saw as far as this trial is concerned. So this show is all about deconstructing, all about breaking it down. And Rob, you have a unique experience because you have actually tried at least 2 federal cases, and 1 state case in the midst of COVID, which is huge.
Yeah, so during I've done 3 federal cases during COVID and 1 state case, and that presents a unique dynamic in terms of we're so used to, when doing a trial, of following up or watching facial cues to see how a jury is receiving what we're saying, or how a jury is receiving what a witness is testifying to. If they're making a face at what someone says, you say, okay, look, I need to follow up. Maybe I need to pull back or not go into that. And when you're wearing, or when the jury is wearing masks, that's taken away from you. And it's hard to read them. So it's hard in terms of to read them during jury selection, hard to read them during opening or closing. While talking about opening and closings, there are times of where during closings that I can tell, okay, look, they're not really feeling this. They don't like this. I'll go in a different direction but with masks, you don't know. You're just talking and you're missing some of that. And I think that may have added to why I think people just talk too long during closings, or especially the defense, because you're not seeing people maybe give you those facial cues or recognitions like, come on, let's wrap this up. You're going too far. But in terms of the trial itself, it's rare in that I've seen different statistics as to how many police officers since 2005 have been charged with murder or pled guilty or been convicted of murder. But it is rare across the board to not only convict a police officer, but to charge a police officer. So one thing that kind of struck me is the lengths that the prosecution went in terms of presenting their case. There's a lot of redundancy, for lack of a better word, in terms of the witnesses that, you'll have, in an ordinary, course of trial, you'll probably have a couple of eyewitnesses, but they had numerous eyewitnesses, 6 medical professionals, numerous police officers, and I think that shows you that this is how much you have to do or what it takes to overcome some of the natural inclination that people may have against convicting a police officer.
Mm. And so you tried a case, if I recall, last summer, when we were really was it summer or the fall? We were really in the throes of COVID for your federal case. Was that in the summer?
I did one in the summer and then state case in late fall, and then 2 federal cases this year.
Okay. And so for those of you just tuning in, that is what we're going to focus on first in terms of what the main differences are in trials in the normal world, if you will, versus in the COVID world, because a lot of things that you would expect to see, even little things, being able to move around the room, being able to stand in front of the jury box, but to be able to approach a witness to hand them an item, like all of those things are very different where we are in the midst of COVID. And I remember when you were trying your case in federal court, it was, first of all, it's too soon. You worry about the safety. You can't have people sitting side by side in a jury box. And then that addresses can you really see them? Can you really gauge their expressions? Or if they're behind you, if they're at an angle, can they really see the witness? Because in a typical courtroom, if you've ever been in a courtroom, you have the prosecution is closest to the jury box. The jury box is closest to the witness. And then the jurors can obviously see all of that better than defense counsel. We're the furthest away from the jurors and we're the furthest away from the witnesses. But I think what's fascinating in this case and in cases that you've tried, what do you think the main thing that is lost? I know you said the facial expressions, you can't see the facial cues, but how do you think that affected witness testimony specifically? Were they allowed to take their mask down, or did they testify with their mask on during the time as well?
In all the trials that I've done, witnesses were required to remove their masks while testifying. So like the judge in each case stated, it's important for the jury to be able to judge the credibility of that witness. But along with that, though, which I did not think of at the time, or didn't until we probably got into it. Your client is wearing a mask the whole time as well. So you're worried about in terms of what message is that sending, or how is the jury, any implicit bias against that does the jury have against your client? Like probably a jury, it's probably against them in some way because they think, well, your client is here, they must have done something. So you're already trying to overcome that. And now you're dealing with the jury trying to gauge in terms of how trustworthy, what do I think about your client, and not being able to see your client's face.
And so when you were doing your trials, did you lower your mask when you were doing questioning, or did you keep it on?
I lowered mine whenever I was talking. Now in the federal case, federal trials, we were allowed to do that. So I didn't wear my mask while I was talking, and would only wear my mask when talking to a client or, approaching the bench. In the state case, we had to keep our mask on the entire time. Mm-hmm. So the only time we could remove it is when we stood up for introductions, because then we're not speaking at that time. But for all other aspects of the trial, everyone had to keep their mask on except for testifying witnesses.
Okay, so for those of you chiming in, definitely let us know what questions you have as far as this trial is concerned. The question I want to ask those of you who are tuning in at this point and drop it in the comments is, what did you think about the trial in general? Besides the verdict, what did you think about the trial itself? Because we're talking about 2 weeks, which is about right, which is what we would expect. But what are your thoughts? So let's first jump into the actual charges itself, because I think some people were confused as to the differences between second and third degree murder versus manslaughter. And there was a lot of pushback, at least initially, that a lot of people felt like it should have been first degree. So the difference is that first degree requires premeditation and deliberation. And I think the state or the prosecution was correct not to overcharge. But that doesn't happen in the real world, because in the real world, people get overcharged all the time.
Right.
And especially for you, Rob, having been a former prosecutor, do you think that it was meticulous enough in the charging stage? Because initially, had this gone, well, let me just step back, take it a step further, because I think what's particularly important in prosecuting a case, especially such as this, like, what's the narrative on the front end? And the narrative that came in on the front end, particularly from Minneapolis. Do you remember? I don't know if you saw it, what their original statement was in terms of what happened.
Yeah, that Mr. Floyd died from, paraphrasing, I think, like from a medical condition.
Right. And so for those of you watching, if you didn't know this is what just blows the mind. But this happens every day. So imagine if this wasn't a high profile case and people who have been either brutalized or killed by the police specifically. I'm not talking about everyday people, or everyday crimes as far as that's concerned. But the original statement by Minneapolis, as far as that was concerned, was that, there was a call to service. He resisted. He had a medical emergency and he died later at the hospital, which is incredible. It's incredible. What if that had been the narrative? What if that was the information that was provided? And what if that young lady had not had the courage to stand there for that full time to be able to show what really happened? Because you and I both know body cams are helpful, but it only shows you whatever it is pointing at the time. It doesn't show you the full scene. So as a former prosecutor, what did you think about the charging process in terms of what they submitted to the grand jury? Was it on point, or do you think they should have done or could have done more?
I think in terms of, like, for first degree, it requires premeditation, some premeditation and deliberation. And, at least what we have in North Carolina pattern jury instructions is that premeditation and deliberation can occur over some period of time, no matter how short. And, prosecutors will always say, in terms of, amount of time it took me to snap my fingers, the amount of time it takes you to pull the trigger on your gun, that can count as premeditation and deliberation. And I think if this was, and this is just gut feeling, but if it was anyone else but a police officer, I think that is going to be given a lot of thought. They're going to give more thought as to, hey, are we going for first degree, and then we will offer something, later, or let it wash out at trial. So because it is so hard to convict statistically in terms of a police officer, I can see or understand why they only went for the highest charge being second degree, unintentional murder.
But do you think that, and I think you raise a good point, it had been an ordinary citizen at the point that it's 9 minutes, how do you not have premeditation and deliberation? It wasn't just something that's, oh my goodness, it happened, or oh Jesus, it was an assault, but the time that you continue to leave the knee there even after death has occurred, all of that. So do you think then, with the differences between the two, because obviously the second degree is the death that was created by the felony that was committed, which was of course the felonious assault. What did you think about the instructions as it related to the inflicting of the substantial bodily harm and all that? Well, let me back up, because I was blown away that he read the instructions before closing. Of course, we're not used to that in North Carolina. I was like, wait, What is he doing? Yeah. So in North Carolina, you get up and close, and then they get the instructions. So that whole reading it before the actual closing, that blew my mind. What did you think?
Yeah, I had to actually check with a couple of people. I said, like, wait a minute, we don't do instructions until after, right? Because I thought maybe, if I missed something in like 20 years or forgotten in terms of how it was supposed to work. But so I thought that was unique, and that I guess if it gives the jury in terms of, hey, this is your roadmap, this is what you need to be, listen for as they give their closing arguments. And I don't know if that's necessarily, better or whatnot, but that's the only way I can see in terms of what, the benefit of going through that. But I was surprised just in terms of that we use lesser includeds, meaning that, prosecutor can charge for crime A, but the jury can also consider crimes B and C because they're considered lesser included. Sort of they fall underneath the bigger charge. But for them to indict for 3 separate offenses, and it kind of seems as if like they didn't quite relate, or they could contradict each other in a way. I was surprised by that. But that's probably a virtue just not practicing there.
Right, because for us, it would be first degree, and then the judge can instruct on whatever lesser included that still may fall under there, so long as there's substantial facts to support it. But then do you think, of course, him being found guilty of all 3, from what I can tell, that obviously he's only going to be charged on the top count. But what message we understand that as attorneys, but what message do you think the jury sent by convicting him of all 3 versus just focusing on the second degree and then finding him not guilty of the other 2? Do you think that mattered?
Yes, when it was announced that the jury had a verdict, that's where I thought they were headed. That they say, look, this is clearly murder, and we've resolved like these other 2. It's not this. So I get to convict of all 3 is maybe like sending the message to Chauvin, particularly, of the egregiousness of that act, and then whether or not you're saying that it's sending some type of message to the community, which they shouldn't have been factoring that in, but human nature says they probably were or aware of the world outside that's going on. So perhaps like sending a message along those lines of this is not tolerated or can't be tolerated, and we need to do as much as we can.
Do you think they should have been formally sequestered?
I don't think they should have been sequestered. So I'm putting on both hats. If I think in terms of as a prosecutor, and then also defense hat of if I had to be in some type of similar situation. But I do think that, or I agree with the defense that after the killing of Dante Wright, being approximately 10 miles away from the courthouse, I think that I'd agree that I would want to have asked the jury about that, in terms of have you heard about this one, and has this affected your ability to be impartial at this stage? Because you can be partial, make a decision at the end, but you're supposed to be fair and impartial throughout. And if you've heard something else in your community and how your community is reacting, I would think that would have to have affected you some way.
Do you think that was a miss on the part of the defense?
Well, he asked for it, or asked to question the jury, and the judge said no. So then you say, well, hey, should the judge have done that? And maybe it falls under those things you say, and better than I in terms of, we talk about judicial discretion. The judge could have done it, but also didn't have to. And if the judge says, well, look, nobody has brought it to my attention that they are aware of this, so I'm not going to, disrupt the apple cart, so to speak, at this stage in the trial, and have them say something that's going to cause us to have to declare a mistrial and start all over.
So what did you think about the judge in general?
I thought and like I said, I didn't watch the entire trial, so trying, bits and pieces and, and catching updates. But I thought the judge was, for the most part, in terms of fair, making rulings in terms of down the middle. For instance, I was kind of surprised that when we talk about the number of experts, and particularly, and I apologize, I can't remember his name, but the first gentleman who is talking to Chauvin on scene and telling me how he enjoys it, and how the guy who was the guy was an MMA fighter. And
I know you're talking about.
Yeah.
Go ahead.
So he was accepted as an expert as well. And I thought that's probably one of those close calls when, if I'm the defense, I'm saying they have so many experts already, we don't need to tender this layperson. But then you say on the flip side, when the prosecution is attempting to bring in what's considered new evidence on a rebuttal, the judge shut that down and said, you're not going to be able to do this because you have a duty to turn over evidence before the trial even starts. And you're trying to sandbag the defense by not turning this over and now trying to bring it in during rebuttal.
Do you think that's a possible issue on appeal? You know they're going to appeal the hell out of this.
Oh, yeah. So yes, that will be issue in terms of prosecution's failure to turn over all inculpatory or exculpatory evidence. So, yeah, that will be one of the issues that they're going to have.
Okay, so my big question when I think about this trial, who in their right mind would try this case by themselves? Like, I cannot imagine any planet that I would put my whole career out, period, just by yourself.
Yeah, that was a lot. I mean, I had read that the prosecution had 14 attorneys working on the case. I don't know how many in the courtroom. So I saw probably at least three involved in direct or cross-examination. And also saw on the news that there's a fund that is used to defend police officers, and that they had dispensed, or that the defense had used or gotten like almost $1 million. So
right.
Yeah. So even if we say in terms of half of that, being generous, going to your expert witnesses, that's still in terms of enough to bring on, an additional or two, unless the thinking is that you want the jury to see, I'm defending the little guy. This is David versus Goliath. You got the government and all of their witnesses, and it's just me here by myself, standing with this man. But I wouldn't advise that or have wanted to do that. Right,
because they had almost 30 some odd witnesses. I don't know the exact number.
Yeah, called 38 witnesses, but hundreds on their witness list.
So, okay, that still blows my mind. Like,
so we'd have gone like, hey, Ms. Troutman, what you doing for the next year? So all we do is like this one case.
Just, you have $1 million to play around with. You only call the two experts. What did you do with the rest of the money? What in the world? Whatever. Okay, I'm gonna leave that alone. So for those of you who are just tuning in or chiming in, make sure you drop your questions and your comments in the comments, and let us know what you thought about the trial if you have any specific questions. Okay, so we covered jury selection. Let's go back to the thing that I think made people most upset: opening statements. So y'all, let's be clear. Opening statements are just that, statements. It's not argument. It's the forecast of where the state, where the prosecution and defense thinks that they will go. I think one of the problems is I didn't see all of the opening, but I know that you saw most of it. What did you think about what the defense was forecasting the theory was going to be versus what actually came out through the course of evidence?
Yeah, so I didn't see all of them. So what I was able to see in terms of the openings is that I thought they were too long. I'm not a proponent of, as I've, sort of gone along with this, of talking a long time unnecessarily to the jury. Now, jurors may say, oh, yes, you do. But generally, I think, it's not helpful or, to do that. So especially with opening, that is a forecast roadmap. You need to kind of tell them in terms of this is what's going to happen during the course of the trial. For instance, for the prosecution, they went through, I think it felt like every witness that they were going to hear from. And there's no need to do that. You can say, hey, we're here from, a group of people or what have you. You hear from these experts, but you don't need to name everybody by name and say, you're going to hear from John Doe. Then we're going to hear from Sally Q. Then we're going to hear from Jane. Then we're going to hear from Sally. That's too much for me. Now, and I don't like trying to second guess people because it's hard enough, being in that arena. But I felt like it was too long. And then with the defense, it's one of those things of you got to play the cards that you dealt. That's the only thing that they had in terms of, I think I had read that they would have pled to third degree, obviously, but Justice Department, took that off the table. So if you're looking at, hey, second degree is what the offer is, maybe they're in that position of, well, we might as well kind of go for trial. It can't get any worse, or maybe it can.
Well,
but, that remains to be seen in 8 weeks, right?
So, okay. And then after, who do you think the superstar witnesses were? Who do you think made that you were able to see? Who do you think had the most lasting impacts?
The pulmonologist for
Dr. Tobin. He is like my medical bae. I was like, oh my God, you were so adorable. Like, you were so adorable. And he's just like that. He teaches. He was incredible. I was just like cheering for him. If I had confetti, I'd just be throwing like confetti. Oh, he's just amazing. Okay. Who else?
So Tobin, the first guy one of the first guys who testified, we mentioned earlier, who had the mixed martial arts background.
Mm-hmm.
I thought he was effective. And the police chief. That's another thing that kind of makes this unique in terms of from these other cases, is that you had law enforcement multiple come in and say that this was wrong. But to have the police chief to say, hey, this guy used to work for me and that was unacceptable. We do not condone this. We don't train that way. So I would say those, Dr. Tobin, the police chief, and the mixed martial arts fighter.
Okay. And what about least effective?
Yeah, I don't know in terms of if I felt the ones that I saw, if I felt that didn't do at least like what they, were supposed to do, or what information you're supposed to get out from them. So the goal is that everybody you put up, you're getting out something useful. Now the question becomes, well, hey, do I need to call all of these people? And does it become cumulative? And maybe there's an issue with that in terms of, hey, all of these people shouldn't have been allowed to testify if they're just going to say basically the same thing. To say, hey, I was there, this is what I saw, that's already been established. Or the police officers, do you need that many to come in? If I'm the defense, to say, Judge, they weren't there, all they're going to do is talk about that this was excessive. That's been established. We don't need to call multiple witnesses from within or outside the department just to say the same thing.
Well, he didn't raise any of those objections either.
Well, no, he did not.
What in the world? Didn't even just the I thought I had jotted it down, but the expert that came before the medical examiner, who I think frankly could have completely ruined this case. And I think that's probably why they use so many experts, because he didn't put obviously he put cause of death as far as homicide, obviously the police conduct, but he never says asphyxiation. He says cardiac arrest due to, and that just left too much open. I think there was a few places, and I will get to this in a second, where there were misses, where the defense, for example, could have really relied on that. It's almost like he wanted to impeach him on some of his other transcript testimony, but he just never did. It was kind of like, so you testified and, you said this and, transcript. I'm like, well, oh snap. What did the dude say? Like, oh my God, is this bad? But he never introduced it. He never went through it line by line. He never pointed out any of the inconsistencies. And that was a miss. But I think the biggest miss collectively with him, among other things, it's just, you just pick a theory and stick with it. Like, you all over the place. It was it reasonable? Was it not reasonable? Was it the drugs and the toxic brew of all of this stuff going on, or was it? It was too much. It was just throwing whatever you could throw out there, and whatever sticks, maybe that's enough for reasonable doubt. But why is that a problem for people who, a lot of people I saw either through questions or through the live were saying he's just throwing stuff out there to make it stick? Why? How can that be effective for somebody who doesn't know any different? Or can it be effective?
Well, yeah, and I have this discussion sometimes with clients where they say, "Well, look, we need to bring this up, we need to bring that up. You have all these inconsistencies, and conversations can be along the lines of every inconsistency does not have the same value, and you have that one shotgun approach of where you're just like, hey, just throw everything and then you have so many, and you're saying, hey, there are just so many, issues of reasonable doubt. That's why you should acquit. But I think it's better of where your argument has some base in some part in terms of on logic, and you're not asking the jury to make too many leaps or too many leaps in logic. So when you're asking to do that, I think that's when things go badly for you. So I do think it's better to look. This is our theme. This is what we are saying has happened, and that's what you're pushing throughout. Just like you were talking about, like during closing arguments. First thing he does is get up there and says, hey, this is what reasonable doubt is, instead of getting up there and saying, no, my guy's not guilty. This is our story. This is what happened. You got to say it like you believe it.
Yes. Oh, but I do want to get to that real quick, because I thought the reasonable doubt instruction was really interesting. So, for us in North Carolina, is doubt based on reason and common sense arising out of some or all of the evidence or the lack or insufficiency, as it may be, blah, blah, blah. Like, we know that. Their instruction, and they don't put the language in there, or we have the additional language. I know you and I do it a lot in trials, that you must be fully satisfied or entirely convinced of the defendant's guilt. Like, that's what we focus on, because you can't possibly be fully satisfied if this is a problem or if this is a problem. Right. But their instruction doesn't include that. They only talk about, it never says fully satisfied or entirely convinced. And they add that language that, as a prosecutor, because y'all used to do this or would do this all the time, about that whole long instruction about the fanciful doubt and all that. And nobody knows what fanciful means. Let's just start there. Like, fanciful doubt, not beyond all doubt, that big long instruction. But the part of that was included in this instruction. It seemed like the reasonable doubt instruction was very short. It sounded like it was going to have the full instruction. And then it goes into, you don't have to be, it's not proof beyond all doubt, some of the fanciful doubt language or whatever. Did you catch that as far as the instruction?
Yeah. So in terms of, that part, because I was thinking, like you said, that's usually the prosecution's argument. It's not, it's not proof beyond any and all doubt. It's not an imaginary doubt, fanciful doubt, created by counsel. I'm like, you let the prosecutor say all that. I don't, you don't need the judge kind of commenting on it. Or like you say, like flip side in federal court, of where they don't even define it. They say, what reasonable doubt is, and I'm not going to define it any further. So,
ain't that the truth? But I think, but do you think that does that make a difference? Well, I don't know if it really made it. Let me ask you different. I don't know if it really would have made a difference in this closing, because there was just so many things wrong with the defense closing. From why are you showing the video so many times? And I couldn't understand why that was helpful. Like, sir, you're showing this man in anguish repeatedly. Like, why are you doing this?
I would have had that the furthest thing from, it's sort of like when, like, the prosecution will use like the murder weapon in their closing. They'll have the gun or something like, like that. Then they'll leave it out for when you get up. And when I get up, I push that aside. Y'all don't even need to look at this. We're not talking about this anymore. They've seen that. So in this case, they've seen that video ad nauseum. Every witness, is talked about it. They've used it in closing. We're not going to get up there and use it in closing as well and play the part of where you hear the deceased crying out in anguish. They're not going to hear that through us. So I didn't get that, in terms of, if there's something you want to draw their attention to, because they can ask for it, or what have you. You can say, hey, you asked for this video. You're going to see the part of where I'm talking about, but we're not going to play it with audio. So you can hear everything.
Repeatedly.
Yeah.
Like, what are you doing? Or he talks about, y'all are focusing on the 929. What about all this other stuff that he did that was okay, that was reasonable? Which I couldn't understand. It's like, what are you trying to say? Because he was reasonably behaved for like 11 minutes. That's supposed to negate everything that happens at the 9 minute, when the clock starts ticking. It was just really unbelievable that that's what his focus was. Because at this point, if you're going to, at the point that, I don't even know if I would have asked a judge to put in an instruction about the reasonableness of the use of force, period. I don't know if I would have even asked for that. What do you think? Because I was
Well,
like, when I heard that he included, I said, well, damn, like, is he really going and saying that this use of force was reasonable? Like, is he really going to go there? But I don't know. I don't know if that helped him or hurt him.
yeah, and I was thinking when I heard that, because I had missed the terms of from the beginning, and I think that goes to when people say that read the jury instructions before you start, and then that will kind of guide you in terms of these are the things I need to be trying to pull out. And I think their jury instruction includes in terms of reasonableness use of force for the police officer, which kind of goes, okay, well, this is why the prosecution was hammering that point so much, because that is something that's going to have to be proven at the end, that it is excessive force for the police officer, and that, ordinary course, when we talk about immunity that police officers have, they are entitled to use force. They are entitled to use, in terms of get aggressive, what have you, and that occurs when making arrests. But the prosecution is saying that, hey, we have to overcome that by saying that it was not proper in this case. That's probably like they kept hammering in terms of calling so many witnesses. But then I think that goes to the point of when you say cumulative, and maybe that's something the defense could have objected to. There's too many people coming in just to say the exact same thing.
Mm-hmm. And so, Patrick, Stacy, I see you guys. I think one of the things they did add an instruction about opioid use, and the instruction was it has nothing to do with the character of George Floyd, which I thought that was an interesting instruction. But then it almost felt disingenuous because it's almost highlighting the fact that what we already know, that George Floyd isn't on trial. Like we know this. I wonder why they felt like they needed to have that as part of the instruction, because his character should have nothing to do with what the defendant's culpability is or what his actions are.
Yeah, and I don't even see why that would be a proper instruction for the court to give. It seems like something that's what, that'd be left for counsel to argue. So I assume in terms of prosecution asked for that instruction, and I don't know whether or not the defense objected to it, but I would assume that they would.
Child, we don't know.
Right, yeah.
You should have, because it's still, again, that doesn't have anything to do with culpability for what his client would have done. Okay. Sure. All right. So what do you think the highlights then of the prosecution's case from what you were able to see? What do you think was strong? Did you think that the attorneys, well, two questions. What did you think was strong overall? And what did you like about the styles of the prosecutors that were the two leads primarily?
Right. Well, strong, or what helps, is obviously the video. If you're a prosecutor, it's probably rare, or majority of the times you don't have the crime captured. I had someone say that a picture is worth 1,000 words, so a video is worth 1,000 pictures. So to have a video of what happened, that's a powerful tool for the prosecutor to use. So having that, the eyewitnesses coming up, I thought that was good. Obviously, having witnesses there who were able to testify, that's good for the prosecution. In terms of style, I found that, and maybe in terms of I was thinking in terms of maybe what we're used to or what we see.
Everybody was dry.
Yeah, across on this type of case, it's like there's no emotion or passion for what you are doing, and everybody doesn't have to have that. It's like different styles. You got to do what you feel comfortable with. We know there are people who are more dramatic and have that fiery preacher style. I can't do that, convincingly.
I want to point that way. Yeah, like, I can't. Yeah.
Well, yeah, I don't see what somebody else over here. Yeah, it's yeah.
Oh, I'm sorry. I meant this way. Sorry.
Yeah. So you got to do with what's best for you. But but no one seemed like they had, in terms of energized, in terms of what they were doing. Now, what I did like, in terms of the last line from Blackwell in the rebuttal, where he said that, you've heard a great deal about George Floyd, that he died because his heart was too big. It's like, no, he was killed because Chauvin's heart was too small. That's a good, line to kind of like tie it up, and a good line like to to end
But
on.
the delivery was still like, it was like
Yeah,
great line. And it was like plunk.
yeah,
It's just like, especially and particularly for those of you watching, I think the thing that I think about this trial that is so important are the nuances that are missed. Like if you caught us or go back and watch the replay, we were talking about because Rob has tried cases in the midst of COVID, the mask and all that. But I'm sitting here thinking like, you're stuck behind this plexiglass, you're stuck behind this lectern. If you can't really move, then the emotion's going to come from your voice. It's going to come from your inflection. It's going to come from your pace. And it was like, there was none of that. Like, well, Stephen, I don't want to say his name wrong. The
yeah,
one
sir.
that did him. I mean, he had moments. I honestly say this, and I'm just real. They needed a strong woman or somebody with some energy,
Yep.
because it was just like, you've got all this great information, you've got all these great witnesses, this emotional piece. Like, where is the ebb and flow? And I guess maybe we're spoiled. We're just used to we're just used to seeing high levels of energy, and maybe they were playing it conservative for some reason, but I just don't understand why it was just so, it was dry as dust. It was just dry.
And I was because actually I was talking to my mom about that yesterday, about how they just all appeared, and I was thinking maybe in terms of, we're in trial pretty regularly, but they're with the Attorney General's office,
Right.
and if we think about the amount of times that we see the Attorney General's office come down on a state case, is probably rare. I mean, I only can think maybe like of two where I had other agency outside of that local prosecutor's office. So maybe it's a function of, hey, they just aren't in court that often. But I don't know.
Well, one thing I think you and I can both agree on, there is no way in hell we would have had almost a 3-hour closing.
Oh no,
Like 30 minutes is long. Like
no.
30 minutes. I think for, maybe an hour. I could see an hour, but 2.5 hours. And then he took a break and still was you were still talking.
Yeah, that would have been your cue, everybody's cue to, kind
The
of
judge was like, yo, we need a break.
But
like,
that comes up to, like, for the defense, I mean, that you don't start your closing during lunch. If prosecution, prosecution starts and they end at 12, then you need to say, look, Judge, this is too close to lunch hour. I'm not going to be done by 12:15, 12:30. So that I don't have to break up my closing, let's just wait. Because you don't want a lunch in between closings either, but it's like lesser of two evils. Right. Do I want the jury to go to lunch and be thinking all over lunch what the prosecutor said, or do I want to start and get cut off? So I'll start only if I know, look, Judge, we can start now. I'll be done right when it's time to go to lunch, and then let them go and think about what, everything everybody said.
Mm-hmm. And so then the last things, of course, the length of time was just incredible. And I think, like I said, we can agree that he had probably no business trying that case by himself. Do you think, and of course, I think we know that how we would normally answer this as defense attorneys, do you think he should have, the defendant should have testified? Do you think it would have made a difference? Because I saw that question pop up too.
Yeah, so testifying is always cost benefit analysis, meaning that what am I going to gain versus what am I going to lose? In the case out of Dallas, when she, broke into his home and, killed him, that police officer, she testified, still convicted of manslaughter. Testifying would have helped him to try to humanize himself as much as he can, if possible. And maybe that would help, in sentencing. But he'd have gotten eaten up on cross, because, they would have played that entire video and probably would have done it in like 30-second increments. Okay, like, what are you thinking at this point? Okay, you still think you need to put his knee on your neck? Okay, let's go another 30, 45 seconds. All right, what have happened? What are you thinking at this point? And he couldn't. I don't think he would have been able to, give any type of reasonable, believable explanation. So short answer, it would have hurt him more than it helped. Because you think, what would he try to have gotten out is, hey, I didn't kill him, but the defense already has their experts to try to say that. I don't think he could have added anything more that would have stopped
He
this.
would have tried to say I didn't mean to, but then you got all the testimony that would show otherwise. King said he would have gotten backed into a corner. It was too risky to put that punk on the stand. That's one way of looking at it too. Yeah, it's definitely too risky to put him up there.
And
couple of
could
things.
he hit his? Oh, sorry, but could
No,
he?
go ahead.
Yeah, then the jury is going to be looking like at his facial expression, his demeanor. How is he acting when this video is being played? Are they going to say, does he look like at any point that either he doesn't care or is like no big deal? There's just like too many unknowns to like put him on the stand.
But I do think the defense took some liberties, and I get why the prosecution asked for those instructions to be read, because there was a few times I was only halfway listening. I was like, dude, that ain't even what the law said. Like, I jotted it down in 30 seconds, and I noticed a few times he was misstating the law, or he would say this is what he was thinking or what he was feeling. And of course, your client hasn't taken a stand. You can't put together what he may have been thinking or feeling because you don't know any of that. Your client didn't testify. There's no state of mind out there other than what the circumstantial evidence is out there. So I thought, I found myself yelling at the TV. Then I'm like, how y'all not going to object to that? And I guess sometimes it's, we know sometimes it's not worth, raising the objection. But when he said that a few times about what he was thinking or what he was feeling, and nobody said anything about it, that's the risk you run. Because I remember from the jury pool notes, I think it was on HLN, they were saying that one of the things they noticed is there was one juror, I can't remember the name, that he was listening intently towards the end. He was nodding his head. He was writing everything that defense was saying. And that's what was a concern for me, but at the same time, you can't really read that body language. They may be nodding and agree with that until they get back in the jury room and they start deliberating. But I think there's a few things and jump in as far as what you thought, the things that you thought that were subtle. Like I thought the medical experts were good. That's still a risk because there were a couple of places where they contradicted themselves. I thought their defense experts, they didn't even look like they were well prepped, because on cross, it wasn't even like they were going hard in the paint on cross. But they were still getting them to admit certain things that were obviously not helpful to the defense. And I really needed this defense attorney. All these open-ended questions. It was just like, dude, have you not done a cross? It was like a whole lot of, so what happened here? Or why do you think that way? No, sir, that's not how you ask the question. It's like, no, what you think is this, or what you said is this. It was so, and I know you doing trial tactics and teaching trial advocacy, your head had to have exploded 50 times when he was asking these open-ended questions of these witnesses and not putting them in a format and locking them into an answer. It was crazy.
Yeah, and I think that's kind of like throughout in terms of, I think, we had discussion earlier of, not asking, the question that, you don't know the answer to. You don't have to do a cross-examination on every witness. Sometimes, you just, you can just thank them and let them go on their way. You gotta, and that goes back to, hey, this is what this is the theory of my case. And if this isn't going to align with that, or I don't need to attack that, just let it go. But there were like cases, even like with the prosecution and the defense in terms of their closings, when you say that, they're both using I, or this is what I think, or I thought this, it doesn't matter what you think, sir, for both of you. But, something that Blackwell, prosecutor, in terms of getting out, which, he shouldn't have, but, I know he's from Fayetteville, North Carolina. I shouldn't have known that. Yeah. Right. But that came out in his opening. There's no reason for me to have known that, but hey, he slipped that in that because, hey, George Floyd is from North Carolina. He said, hey, that's not too far from my hometown of Fayetteville. Okay, that's good. But what that got to do with anything? Yeah. Technically, that should not have been coming out. But yeah, so a couple of those things.
Well, I think that may be part and parcel. And I think you make an excellent point. I mean, it doesn't appear that defense counsel was an experienced trial lawyer. He may have been, no shade. Well, sort of. Yeah, there's shade. Because it was just too many mistakes. It was too many mistakes, a lot of missed opportunities. And each time, I don't think he had one. Well, he did have some good. He did have, even initially when he was crossing Genevieve. Oh, I can't remember her last name offhand. The EMT worker. Like he was making those mistakes early, trying to attack your emotion witnesses or the state's emotion witnesses. And that's always bad. Like, you can't go and antagonize the people who are having the emotional, that's bringing forth that emotion, or at least temper your cross to where it doesn't appear that you're attacking them, because those are the first witnesses that the jury saw. And I like how the prosecution built the case starting there versus starting with experts or the cause of death or that part of it first. They told the story, I thought, effectively by bringing out that emotion on the front end in your face, then showing George alive. So, and then going into the experts and I'm sorry, the police officers, which I agree, it was too many of them. You didn't need all of them. And then your experts at the end, which I don't really think you needed all of them either, but I think they almost had to, because the ME could have royally screwed this case up if it hadn't been turned over to the Attorney General's office. It was going down that road of either a non-prosecution or some crap that would have never really seen the light of day in terms of justice. So what you think? Anything else that you saw that stuck out?
Well, no, I think, but the part that you said in terms of how this could have ended up, I think that just goes to the importance of video in this day and age, because there are too many cases of where, but for someone getting a hold of the video, even when we think about the Walter Scott case in Charleston, South Carolina, that got called in as, self-defense. The Walter Scott stole or, took his taser and he had to shoot. But for the young man being across the street, videotaping everything, that would have been the official line. Nobody would have thought any differently in terms of law enforcement. So, you think about in terms of how many other cases have there been that, we don't know about or aren't talked about because there's nothing to refute that official line.
And I think that is one of the takeaways as we wrap up into the now what piece. It's like, what do we do now? Because does this send a message? Does this truly send a message to law enforcement that there has to be greater, there has to be consequences, one, for one's actions, that two, you don't get to have open season on Black folks without impunity anymore. But I also saw where the Justice Department is doing an investigation into the Minneapolis Police Department, which would have never happened under the former president's watch. So, but none of that means anything until we have legislation that's actually addressing some of these issues fundamentally, actual reform that's tied to federal dollars. Because, unless these reforms, or even here locally in Charlotte, like, we have police directives that need to be changed, period. And they still haven't been addressed. And who's responsible for that is City Council. And unless and until there's pressure put on them, I'm going to go into a rant, but unless there's pressure put on them to change those directives, it's still going to be a whole lot of the same. And it can't take something like what we've dealt with in Charlotte, with the police killings that weren't prosecuted, or the police killings where it didn't result in a conviction, to get to that point. So let me ask you this as we wrap up. So as a former prosecutor, having done homicide cases, and of course now from the perspective of being a defense attorney, what is it that you would tell people that they can do now? Is this truly a movement? One, and what is it that they can do now to start to push for real reform when it comes to policing?
Yeah, so I mean, that's probably a multi-faceted question answer in terms of what can people do now. So one thing I say every time I get an opportunity to speak, jury selection, in terms of participating in the jury process. I think they say studies show that jury results are more equitable the more diverse the jury is, diverse in ethnicity, gender, diverse in thought, different experiences. So when you get called for jury duty, if you can make it, sometimes people have real world legitimate concerns. I can't take this time off from work. I don't have childcare. But if it's just that, hey, I don't want to be bothered, jury service can be an inconvenience for everybody. But if you want to be able to, have a say-so in how you think these cases, are supposed to go or should go, or, you need to be able to be one of the people that's sitting there and can say, hey, well, look, and I'm not saying, hey, that means you find everybody not guilty. It doesn't mean you find everybody guilty, but it means that you're sitting there and you're listening, and you are making that decision. Now we talk about, hey, is this a movement? Well, because of what happened, that did spark in terms of a lot of conversation, and that is still ongoing. So that's good. Does it change anything? Does it cause police to now rethink what they're doing? Absolutely not. And this is me being, I'm pessimistic by nature. This trial, but you look at it in terms of at the
It's
trial.
the truth.
They went great pains to say, look, this is not state of Minnesota versus the police. This is just in terms against Derek Chauvin or Chauvin, however, he says his name. What they're saying is, look, what our police officers are doing in terms of the old ordinary course of things, coming in hot, pulling out guns, what have you, that's fine. We don't have an issue with that. They're saying this right here is going too far. So when people say, is that going to cause, stop me when you need to, but is that going to cause police to rethink? No, because you're not having, if you got a police officer out there now who's saying, you know what, I shouldn't keep my knee on someone's neck for 10 minutes and have them and strangle them to death, then that's a bigger problem already, that you got people like that's on the force. But the way these things are happening before the jury verdict, or as the jury verdict is read, you have the killing in Ohio. Wednesday morning, you have, I just saw the article today, in Elizabeth City, officers are going out to serve a warrant. He drives off, deputies shoot and kill him. And I didn't see anywhere in the article where he's driving towards them. So these are things that are still ongoing, and you can't train out racism. So I don't know in terms
oh
of
my God, Rob,
where
I
do you
was going
go?
to say that. Say that again.
Yeah, so
Please
you can't
say that
train.
again.
Yeah, you can't train out racism. So in terms of what you need to do, it has to be, and I'm not the one to kind of come up with what happens, but it has to be deep, systemic, transformational, in terms of change across the board with law enforcement. And I'm not saying this, I'm not in the camp of abolishing police, but also can recognize that just because if you get rid of police doesn't mean we're going to automatically turn into the purge and it's going to be this rampant crime. But there has to be, some hard, discussions and people sitting down and saying, look, how are we best supposed to support and protect our community? Because current model obviously is not working. Because it's, I think someone was telling me yesterday on social media that 90% of the shootings or killings by police officers involve citizens who are armed. And my response was, well, no, what comfort does that give to the remaining 10%? If you're saying, hey, 90% they had something, and armed, we know does not just mean gun.
Right.
Armed can be you had something in your hand, because the argument prosecutors use that anything can be considered a deadly weapon depending on how it's used. So armed doesn't mean there's a gun. So, but even if you say 90% are armed, what are these 10%? And 10% is too high.
Right.
So in answer in terms of what can be done, I'm not smart enough to be able to come up with that, but I know that there has to be something, and more discussions have to be made in terms of how we are utilizing, or how our police force is created to protect us, or supposed to protect us or our community.
So what made you make the decision to decide to leave the side of being a prosecutor to go to becoming a defense attorney?
Oh, so I don't mind sharing that one at all. I've always, not always, but for a long time, I had thought about being a defense attorney. And I saw TED Talk by Brian Stevenson and from Just Mercy. And I was still in the prosecutor's office at the time. I said, wow, if I ever became a defense attorney, that's the type of defense attorney I would want to be like. And the attorneys that I admired the most locally were defense. But, sometimes when, you can't make that move, God makes the move for you. So I was at the point where a decision was made for me. And I'm glad that it was, because I'm more stressed on this side, but I'm happier in terms of the work that I'm able to do.
Amen to that. Amen to that. And it's, for me, it was the same thing leaving the bench. Like, it was important work to be done, but I was losing myself as an advocate I was just losing myself as an advocate. And of course, I speak, jumping into that had everything to do with it as well, as far as teaching the kids about the system so they don't become a part of it. So as we wrap up, and especially if you're catching this on the replay, definitely make sure that you go to like, follow, and subscribe. Now, if you want to, and I also you definitely need to be going and following Rob, because he's got cool social media, especially for the law firm too. Robert K. Corbett, ESQ, on Instagram. His number is 704-401-5299 if you need to reach out to him. We're kind of like a Bonnie and Clyde at this whole breaking down trials thing. This kind of our thing now.
And so hopefully, we can do one that's kind of like maybe a happier one, if those exist. But yeah.
Well, I was happy yesterday. Let's not get it twisted. Oh, I was happy yesterday. Sure. There was libations and a cigar. I had a whole Justice cigar, Rob. I had a whole cigar that I called Justice and smoked the hell out of it on my patio last night. Okay. But I do think, all jokes aside, and it's interesting that you say one of the things that we can do is jury service. I see where one of my former jurors, and if you're still watching, I see where she chimed in. And I remember her specifically from a trial. Oh my gosh, maybe 2011, 2012. And I can't remember, Ann, if you were the foreperson or not, but she and I bonded after that trial and through social media and all of that. And she was talking about, what her service was. Yeah, she said she was a foreperson. And I think it was a drug case. I can't remember what case it was. If you're still watching, Ann, chime in. But she is a great example of why jurors matter, because it was so important to have jurors who one, take it seriously, but will also listen to the evidence and really, really follow the law. And that particular jury, I remember, was so talkative. And some of the things, and I know you have it when you go talk to jurors after, they pay attention to everything, from the jewelry you wear to how, if they see you out and about or whatever the case, they definitely make sure that they are paying attention to everything. So jury and service is incredibly important. And then the last thing that I would suggest to those of you who are watching is to make sure that understand that part of this, as far as real police reform, is going to have to come from a legislative perspective. So that means you need to pay attention to who's on your local, who's up for local elections, what their roles are. If it's important as far as police reform, emails, letter writing campaigns, calls, because we're so reactive. Like, something happens and then we're up in arms and then we want to do something about it. And we have to get away from being so reactive to a situation to being proactive in terms of making that reform happen. I think this case has sent a message that it can't be business as usual anymore. Now, we'll see what happens with these other officers, what the charges will be, and how those trials will go. But it shouldn't have taken 2 weeks and almost 40 witnesses, and we still had a possibility that this man could have come away acquitted. And I think that's the thing that I find disturbing, because why did it have to take this much in order for us to get to this point, when countless Black men and Black women have been murdered at the hands of police and they don't even get charged? So a lot of this is going to depend on who is your district attorney. What are their policies? How do they evaluate cases? Who are your state legislators? And then, most importantly, to start putting pressure on your senator and your representatives to get that George Floyd Act passed. We have to start to have national standards. All of that has to happen on a legislative level. We can protest, we can do all of that, and there's for that 100% of the time. But for substantive change, where it's going to affect the pockets of these police departments, where there's possible federal funding that can be pulled or federal investigations, until those types of things happen in terms of accountability, we are going to have problems. We're going to continue to have these problems until that act is passed. With the Justice and Policing Act. Thanks for that, Kenya, because it was on the tip of my tongue. But also needs to happen at the state level. North Carolina is horrible. Like, I love how Minneapolis, there was video out immediately. It's so hard for us in North Carolina to let alone get body cam, let alone for it to become public. We have so many restrictive laws just within North Carolina in terms of disseminating body cam use. And that's something that has to be done on a legislative level. Those are the types of things that we need to start having those conversations about. And we'll do that here, and how we can start to galvanize. What do you think as we wrap it up? I know that was long.
No, but I think that's like nail on the head in terms of that it has to be addressed locally. So your local government that funds the police department, when you talk about in terms of we need to reallocate funds of, going toward what have you in terms of social services, mental health, that comes from local government. And then as well as, your state government, where the example you gave about body cam footage, but it has to be addressed locally, or you focus more in terms of locally versus in terms of what or anything the federal government's going to do about it.
Absolutely, because that's going to be more so a funding mechanism. But if we have directives that don't, for example, potentially fire an officer if they don't have their body cam on, but it's like, oh, I just didn't have it on. No, there has to be if there's no consequence for that, who's to say that you cut it off? Or I've had cases where, the way that the body cam directives, it leaves too much discretion of when you can turn it on and off, if you declare something an investigation or not. And I wholeheartedly agree, those are things that have to be addressed on the state level for sure. But on a federal level, when you start talking about dipping into those pockets, then that's where it matters. Even with sheriff's departments in smaller counties where they are in charge of the majority of policing, that's when county commissioners, or however that city is organized, whether city council or commission or whatever, I agree. The pressure has to come there, and there has to be accountability, and we have to stop being so reactive.
Well, another thing with in terms of when we say local, state level, the qualified immunity issue.
Speak on it.
Well, I mean, and that goes to probably those who do more in terms of civil, but qualified immunity, I guess, in short, in terms of protects police officers if they are doing something, or the argument is during like the course of their duty, and it makes it harder for lawsuits to be successful because that's a high burden to overcome. And I know some states have, at least a couple have that I'm aware of, have moved away from that. So when you talk about in terms of, hitting pockets or agencies, if you're going to be held for financially responsible, more often, I think the thinking is that people are, going to give maybe, you hope maybe a pause to what they're doing. That, for Ohio, tragic situation, chaotic, lot going on. But is there any thought given to, as he arrives at this area, to break up this fight, short of firing his service weapon? Is it, shooting in the air? Is it deploying taser? Is it using pepper spray to kind of get people dispersed instead of pulling out guns?
Shooting out the gate. Yeah.
Shooting her 4 times in the back.
Why does the reach have to be for the gun first? Why does that have to be the first step and not the last resort?
All right.
So as we wrap up, so thank you for those of you tuning in. If you're catching a replay, drop us a comment. So obviously, if you haven't done so already, make sure you like, follow, and subscribe at all things social media at the Convo Pod Show. If you're not already following Attorney Corbett, make sure you do so. He's on IG at Robert K. Corbett ESQ. His office number is 704-401-5299. What's coming up next on the conversation? Our next show, I'm continuing the personal conversation series. I'll be one-on-one with Congresswoman Alma Adams. That will be May 5th, live at 8 p.m. here on Facebook. And of course, on the YouTube channel, we're going to be talking about her story in greater depth. We're going to be talking about her legislative agenda and what's next for her. So make sure that you save the date for that and tune in there. As always, thank you. Thank you for tuning in and the support. If you haven't already done so, go to theconvopodshow.com to catch all past episodes. And then, of course, there's merch there and some other things that are on the horizon. Rob, thank you as always. It's always so much fun to have you on the show. But yeah, maybe we can find one there's no such thing as a happy trial as such, because there's always shenanigans. But we got to find one that, doesn't take so much out of us. You know what I mean?
Yeah. But always willing and able and, available to help you out with this or anything else, any other endeavors that you're working on.
Always a pleasure. Okay, so we will see you guys back on May the 5th. Make sure you like, follow, and subscribe to everything at the Convo Pod Show. Know that this is a first step. It's time to start holding your local governments accountable, your state governments accountable, and of course on the national level to push for legislative changes. But still, we've got to keep foot on the gas. This is just part of it. We've got to keep our foot on the gas because this is a movement we cannot let. We can't let this movement die out by any stretch of the imagination. Y'all have a good night and stay safe.